Your matter. Let's go on the record in the matter of City of Wappers, David Ponce, 25721. Counsel, your appearance, please.
Good morning, Your Honor. Wright Blake appearing on behalf of David Ponce, who's present via Zoom. State your name, Mr. Ponce.
Good morning, Your Honor. David Ponce.
Good morning. And so today.
All right, we are officially at sentencing. This is the moment where everything becomes real. The judge has already reviewed the pre-sentence report. And trust me, that document is everything. It includes criminal history, pending warrants, background, and recommendations. If there's something bad in that report, today is the day it comes back to haunt you. And notice the calm tone so far. But that's about to change.
Is the date scheduled for sentencing in this matter? And counsel, did you have an opportunity to review the report and recommendation with your client?
I did, Your Honor. The report.
And are there any corrections that need to be made?
No, Your Honor.
Sir, tell me about these warrants that you have. Have you taken care of them yet?
Excuse me?
The warrants that it shows you have pending, have you taken care of those yet?
I don't think I had any warrants pending.
Well, you do.
Uh-oh. This is not what you want to hear at sentencing. You have pending warrants. That immediately raises red flags. Even if they're old, even if they're clerical, it signals unfinished business. And here's the thing. Judges hate loose ends. It suggests instability, lack of follow-through, and, in a sentencing hearing, perception matters just as much as paperwork. Now watch how this starts shaping the judge's attitude.
It was on your report, the pre-sentence report.
What were the warrants pending for?
What's that?
What are the warrants pending for?
Judge, we've been to court on several of those. They're still pending, and we're in the process of cleaning all of those up. So Mr. Ponce is a longtime client of mine, and he's working on getting his driver's license, but we always run into a roadblock because of his prior record. But we're getting there, Judge.
Okay, so these two warrants are from 36th District Court. It looks as though these may be pending from 2016. I don't know if there's somehow fines and costs that weren't paid or not, because that coincides. No, it's actually before the matter that your client was in MDOC custody for.
Oh, then those should have been cleared up. If I'll double check to see whether they're still pending, but
one is showing open alcohol in motor vehicle as a passenger. And I think it's from 2016, but the warrant didn't issue until April 30th of 2025. But I could be reading that wrong as a case number for the court docket number.
Well, that's that should have been included and dismissed in the more serious case.
And then driving with revoked license. And it's possible it was counsel, but if there was a warrant fee or fines and costs owed on something, then maybe that's why there's a warrant. I'm not sure. But those are two warrants that are pending for your client.
Thank you, Judge. We'll clear those up as soon as possible.
Okay. So I did have a couple questions prior to sentencing your client, because I have to be honest, it doesn't necessarily strike me, well, no pun intended, as a matter having the A and B is dismissed when there was multiple strikes. But given your client's criminal history, I don't know that fines and costs only is sufficient. So,
There it is. That sentence right there changes everything. When a judge says fines alone aren't enough, that means jail is officially on the table. And notice the subtle reference to multiple strikes. That's a major legal undertone. repeat behavior, pattern recognition. Courts look at patterns, not excuses. At this moment, the defendant should know, this just got serious.
Mr. Ponce, it appears as though, given your history, sir, it doesn't even make any sense that you would even be in a bar, let alone consuming alcohol. You serve prison time, sir, for driving while drunk and causing death. Why are you...
And now the emotional weight hits. Prison time, DUI, causing death. This is why the judge's tone sharpens. In the court's eyes, alcohol isn't just a bad habit here. It's historically catastrophic. When a prior conviction involves loss of life, any return to the same behavior is going to trigger intense judicial scrutiny. You can feel the shift, right? This isn't just about a bar incident anymore. This is about judgment, accountability, and whether the court believes he's learned anything.
Even considering using alcohol and in a bar?
Well, to be honest, Judge, I'm not gonna lie to you. I was going through a real rough patch in my house. Like not even like within my house, I had got evicted. I had lost my relationship. I was going through so much. I wasn't thinking clearly at the time. Not trying to make excuses or sit here and lie to you. I don't know. Everything was going just so good, and then I don't know. It all went bad. It was a bad decision I made on my part.
Well, sir, let me just clue you in on something, right? Life is all about ups and downs. There's going to be days that are easier than others. There's days that are going to be harder than others. But you, sir, should not be turning to alcohol, considering that alcohol landed you in prison. Your choices that you made while consuming alcohol landed you in prison. And here you are, sir. Are you on parole or did you serve your sentence?
I completed my parole with no problems, Judge.
How long were you sentenced to prison?
I was in prison for 2 years.
2 years?
Yes.
You caused the death of another individual?
The victim was my fiancée, Judge.
I understand that, sir. And your sentence was 2 years?
Yes.
Okay. And so given the nature of all of that, sir, why are you even drinking any sort of alcohol?
Honestly, Judge, I was just having such a bad time around that time. I didn't know what to do. I didn't mean to do the things that I did while I was intoxicated or act that matter in public. I haven't, other than like driving tickets since I've been home from jail, I haven't really been in any major problems other than, like this. And then I've been in front of you like for a driving ticket before, but that's it. I started my own business.
I may interrupt. It was a relapse on his behalf, and I was just as disappointed as you are, probably even more so. But he has been back on the path of abstention. He has gone through some counseling, and he's pretty much trying to clean up his life, and he has a business that he's owner of and with several employees. So he's making tremendous strides, Your Honor, except for the one for this particular case, in which he was also a complainant as well. He got body slammed by another individual.
No, I understand. But also your client's currently on probation from a matter that occurred a month after this one, correct? Felony probation?
What's the charge on that, Judge?
Carrying a concealed weapon. Aren't you currently on probation, Mr. Ponce?
Wait, carrying a concealed weapon and currently on felony probation? Now we're stacking risk factors. Even though the judge clarifies this isn't technically a probation violation, the optics are rough, very rough. From a legal standpoint, the judge is evaluating public safety, rehabilitation, and deterrence all at once. And when someone has alcohol issues, prior fatal DUI, and a weapons charge, the court is thinking risk management. This is where sentencing becomes about control, not punishment.
Yes, ma'am.
Right. So this wouldn't necessarily be a probation violation because this incident occurred prior to your conviction on the CCW. But what I am going to do is this. I do not find that there's reasonable grounds to depart from MCL 769.5. I do think, though, sir, that you need something a bit more than just fines and costs. So I'm going to order 60 days on the alcohol tether. That will assist you, sir, in the event that you're having a bad day going and consuming any alcohol. And then you're not to return to Captain's Bar, and then I'll assess fines and costs. The court's going to order a $300 fine, $100 screening assessment.
That right there is a strategic sentence. Not jail, but control. An alcohol tether is essentially accountability 24/7. It monitors consumption and removes the bad day excuse entirely. This is judicial psychology at work. The judge isn't trying to destroy him. She's trying to eliminate the trigger. Notice something important. She could have imposed jail time. Instead, she imposed structure. That tells us the
Cost of prosecution, $300. Crime victim assessment fee of $75. Justice system assessment fee of $50 for a total of $825. You did post a bond of $250, sir. Do you have any other money that you intended on paying today?
I think I maybe have like $200, Judge.
You're paying an additional $200?
Yeah, I have like, I can use the $250 for my bond.
Correct. And then you have an additional $200?
Yes, ma'am.
Okay. All right. So then that will be a total of $450 that is being applied to your balance today. And then the balance of $375, sir. How are you intending to pay that?
I can try to have that paid by the end of this month.
Okay. So let me do this. You said the end of this month? Well, that's next week. Well, yes, actually.
I might need until like, maybe until
30 days.
I'll do March 31st. I'll do March 31st, okay?
Thank you.
All right, please email into probation and they will give you information regarding your tether, sir. So email in there by 9:50, okay?
what do email into who now again?
Email into probation. Counsel, you have that email, correct?
Yes, Your Honor.
Okay. Okay. Good luck to you, sir.
Thank you, Your
Thank you,
Honor.
Judge.
Thank you. Have a good day. All right. And then we are